See, okay. One
Sorry
of
about
the
that. Go ahead.
one of the issues we've been having lately is people not understanding what is involved with dual agency and what it means to both the buyer and seller or the tenant and landlord. Some people think that they have to do dual agency to collect commission on both sides. First of all, let me say that that is not true. You can do no agency with the buyer. You can do no agency with a tenant and still get paid both sides of the commission because you're performing all the work. You're filling out the lease. You are attending home inspections. You're doing everything you would do. The only thing you're not doing with no agency is advising the tenant or the buyer on how to bid. You're saying, here are the comps. You make a decision, tell me what to put down on this paper. What do you want to offer on this house? If you do no agency, you still retain your right to advise the seller on whether you think this is a good offer or not. When you switch over to dual agency, you've robbed your seller of all the advice you could have offered them. You can't analyze anything for them once you give up that right and you go into dual agency. All bets are off. Mr. and Mrs. Seller, you make up your own mind. I can't advise you now. Does that seem right when you took that listing and you told them you were going to represent them and get the best price possible for them? I think it's a mistake. One of the misconceptions in the office also that I've run across is that if you do no agency with a buyer or a tenant, you don't have to pay company dollars on that transaction. That is also not true. The company expects you to pay the buy and the sell side, on every transaction. If you represent the landlord and the buyer and the tenant, rather, you're going to be paying that 10% transaction fee to HomeSmart Connect. The same goes with the sale. All right. I was talking earlier this week to a representative of the Illinois Association of Realtors who tells me that in the new license law rewrite, there is a proposal to ban dual agency in the state of Illinois. All right. We don't know if it will pass or if it will get into the new license law document, but there are a number of other states that have already enacted laws against dual agency. I think personally, I never practiced dual agency. I think it's a mistake and I think it leaves you open to more liability. So I think it's in your best interest to learn how to act differently, not automatically assume that you're going to do dual agency. All right. If you have a relative that you have listed a house for and you are never allowed to do dual agency on either a property that you own or that somebody you are related to owns, because that would be a conflict of interest. You cannot represent both sides fairly if one of them is related to you or if it's your own. Does that make sense to you? All right. Now, we've had another problem in the office, and that is when you sell your own property or when you sell a property for a relative of yours, whether it's on the buy side or the list side, by law, you must have on the contract that the agent is either the seller or the buyer agent is a real estate licensee in the state of Illinois and related to the seller, related to the buyer. Okay. That is required by the state of Illinois. All right. If they catch you, you can be severely penalized if we get audited. We haven't been audited in a long time, so our number is probably coming up pretty soon. So please, please, please be careful. All right. Any questions so far? We have unfortunately been notified in the last couple months of several instances of unauthorized access by our agents in properties that they have shown. What unauthorized access means, and it's a broad term, it could be you showed up too early for your appointment by more than 10, 15 minutes, and they dinged you for unauthorized access, that could be a $2,500 fine. You went to the wrong house and opened up the wrong lockbox and opened up a door that you didn't have an appointment to show, unauthorized access. Another thing, you were stuck in traffic. I got this one yesterday from one of our agents. So she gave her buyers the 1-day code to get into the central lockbox, and also gave them the security code to turn off the alarm in the house. That's a serious
That's so
violation.
bad. I'm embarrassed. That's terrible.
I am too. I am too. Now, sometimes I understand mistakes can happen. Many years ago, I was showing condos in a large building, and in the lobby was a line of like 40 lock boxes. Okay. I opened the wrong lockbox, went up to the door of the property I was supposed to show, and when the key didn't fit, I realized I had opened up the wrong lockbox. I went back, put the key back in the box. And in this case, this was years ago, it was a combo lockbox. So there was no record of me having opened that box. Okay. But if it's a central lockbox, it records your name that you opened that box. So yesterday, I had an agent tell me that she was mistakenly opened the wrong box in a condo building, and she got dinged for $2,500 yesterday for unauthorized access, even though she never opened the door to the property. Okay, so
Wow.
be very deliberate and cautious, especially in a situation where you're sitting there looking at like 20, 30 lock boxes in a row on a railing. Be very careful. Try and identify the right one before you open it, especially if it's a central lock box. Okay.
Was this agent reported by the agent that opened the
Yes.
lockbox? Okay.
It was reported by the listing agent. The listing agent did a printout of everyone who had showed her listing from Central Lock, and our agent's name popped up, and she said, oh, she filed against her immediately. All right.
Do you think you should, somehow find the agent information and type a text message, apologies, we're here, da 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 da, would have been helping?
Our agent is going to try and call that agent today and see if they will, relent and back off. Otherwise, she intends to go to a hearing to try and plead her case. One of the things I will tell you is more often than not, if you go to a hearing, especially if you are actually guilty of what they've accused you of, chances are they will institute the $2,500 fine and give you a continuing ed as well. Okay. So be very cautious. If one of your relatives calls you up and says, hey, I know Susie, my friend Susie, has been listed for 3 months. She's not happy with her broker. I think you should give her a call. Don't do it, because you can get into trouble for contacting a seller that is listed with another broker. If they call you, that's fine. But if you call them, you violated the law. I had an agent in my office a number of years ago whose wife was a photographer, and he thought it would be a great idea for him to scrape all of the listings that had been on the market for over 60 days and send a flyer to all those people saying perhaps if you had good professional photography, your house would already be sold. Well, not only did he get an ethics violation, they fined him $3,800. They told him he had to take the pre-license course all over, and he quit the business. You don't want to take that chance unless you're not doing this for any other reason than entertainment. If you want to stay in this business, you have to abide by the rules. Okay. All right. I think, are there any other compliance issues, Sonia, that you're aware of that we should talk about now?
Hang on, I'm here. I would say the one of the number one compliance issues that we're seeing is just a form, people when they're doing our agents, when they're doing the leases, need to be reminded that there is a lease compensation statement, just like we have a compensation statement for a home sale.
Mhm.
We're doing that for leases now because it gives clarity to the commissions department, first of all, so that they can
Okay.
pay your commission appropriately. The other thing is, we have a form that, Sandy and I were talking about, where it is a rental, uh, agreement for compensation, and that is where you should be on there, and you can check that the broker is who's paying it, the landlord is paying it, the tenant is paying it, whom is paying it. So that form is necessary for giving you clarity. So that would be all I really can add in for that right now. But I would just say that rentals are definitely our biggest headache in the office, bar
Mhm.
none.
Mhm.
People are doing the wrong lease. If it's a Chicago lease, they're doing Cook County instead of doing
Yeah.
Chicago. Cook County is for outside of Chicago, like Elmhurst, other areas. Arlington Heights is Cook County. That's how that would work. So,
Exactly. And we've had a lot of challenges with people deleting pages out of these leases because they think they don't apply. What I would advise you to do instead is to write NA on a page if it's not applicable and leave it inside of the documents, because there are some of the pages, especially in the Main Street lease, and I haven't even looked over the Chicago lease that carefully, but there are pages that pertain to if the property management changes, the landlord has to notify the tenant of a property management change. Or if the bank where the security deposit is being held changes, you have to notify the tenant. So don't eliminate those pages, leave them in the document. Leave the document as a whole, 38 pages, I think it is, and have the tenant initial the bottom of every page, notating that they have seen it. And if it's not applicable, put NA on it. That's all I need. All right. Once again, the disclosures required for a rental, and we've had some confusion in the office. There are agents who think that certain disclosures are only required if you're in Cook County or if you're in Chicago. That is not true. The state of Illinois requires a radon disclosure for all rentals, unless it's above the third floor. We require a flood disclosure for all rentals. We want an independent flood disclosure that is given to the tenant prior to the lease signing. This is what the law says. The tenant should be given a flood disclosure before they ever have to sign a lease. Then there needs to be a flood disclosure also inside of the lease. Now, I've heard from some people, landlords saying, my house isn't in a floodplain. Well, you know what? There are a lot of people in Chicago whose houses are not in a floodplain, whose basements got flooded in the last month, even though they're not in a floodplain. And basically, the flood disclosure says, I'm aware of flood. It could even be the driveways, the garages, the parking lots. If cars get damaged in a condo parking lot in Mount Prospect because the parking lot flooded so bad, the landlord is required to disclose. Okay, so it's not just the unit itself. The unit could be on the 7th floor, but the parking garage is below grade, and maybe that parking garage floods. You need to disclose. All right, so the flood disclosure must be completed prior to the tenant having been given the lease. Now, I would advise you all, if you are going to, because not all of the boards have upgraded their leases to include flood disclosure, because it has to be re-signed inside of the lease, to go ahead and use either a car form or a Main Street form for your lease. Barbara has a message. So difficult to get on, but oh, good to have you, Barbara. I'm glad you got in. Any questions so far? All right, I would like to, if we've got time, to,
Sorry, Sandy, you have to do a lead disclosure too, right?
if the property was built prior to 1978, correct?
Okay, want to make sure.
All right. All right, so Sonia, is there a way for me to put up a document?
Yeah, hold on one second here, Sandy, and we'll make you a host.
All right. Let
Also
me-
just want to reiterate that we are still seeing a lot of people clicking that we hold earnest money in their like
Oh.
listing agreements or on the MLS, correct? And we just need to clarify that we don't physically hold earnest deposits or earnest funds at HomeSmart Connect. We have not for 5 years. We have not since 2020. Um, please reach out to Castle Connect when you have a listing and you want to have that buyer deposit funds for you. Go to the Castle Connect site, put in that address. It will now make it to where when that client drops off funds at any Chicago title location or they use the Castle Connect site, it knows what address to apply it to. And then you can have Chicago Title reach out to your attorney to see if they're willing to work with you for smart title. So that's really the easiest way to go. But again, just a reminder, we do not hold earnest money, and we are still seeing people check yes in the MLS.
And guys, when you make a mistake, when you have a listing and somebody submits an offer on your listing and they check the wrong box, it's your job as the listing agent to tell that agent to correct it and send it back to you. It has to be checked other, okay? Cannot be us seller's broker holding the earnest money. Otherwise, you're going to have to do a lot of repair work once you've got those documents uploaded. Now, if you've let the wrong box be checked, now Doc Review is going to send you a notice saying, we want a receipt for that earnest money because you didn't tell us where it was and you've shown that we're holding it. We don't want to be vulnerable in an audit. So please be more careful and absolutely check your MLS listings. Okay. We have people that forget to check ownership interest. We have people checking that we're holding earnest money. All of those things are not good. All right. They put you in a very vulnerable position. It says, can you please explain? Can you read that to me, Sonia? I don't even.
Yes, it says, can you please explain about the agent that mailed the expired about the photos, saying, you had a terrible photographer, so this is
Yeah.
why
Oh,
your home didn't sell. Why was he fined?
These were not expired listings. These were active listings. And my agent, unfortunately, mailed out this mailer to all of these listed properties saying, guess what? Your property didn't sell because you didn't have professional photos. Clear violation. You are not allowed to contact somebody else's seller. If it was an expired, it wouldn't have been a problem. Does that answer your question?
Exactly. And that's why we always have that little blurb or disclaimer at the bottom of every postcard and every mailer that goes out that says, if this property is listed by another agent, please, ignore or throw away this mailer. In essence, this is not,
Exactly.
we're not trying to
Yeah.
sell.
And-
I'm not doing it verbagely correct, but I think you
Yeah.
guys get the idea here. All right, I
Yeah.
have made you a co-host here, Sandy. So if you would like
Okay.
to share,
I
you should have the opportunity to.
try. It's been a long time. So
That little green box at the bottom, you're just going to click on that, but then it helps if you actually have the form up in the background first.
oh, well, I have it up, but
Okay.
now I don't even know where. Let's see the green form at the bottom. Ah, share. Okay. Let's see here. All right. Now, can anybody see what I'm doing?
See it. We see a corner of it. Can you like,
I will
yes, that's
try.
exactly what you need to click.
Okay.
Exactly. Beautiful. Thank
All
you.
right. Here is our exclusive rental listing agreement. We would prefer that all of you use this document when you're listing a rental property, okay? It's so much easier for doc review to analyze documents if we're all using the same documents. When we've got 6 or 7 different forms, they're going back and forth between the pages and it's so confusing. So let's all try and use the same documents. So is this large enough? Is it easy to read or should I try and make it a little bit bigger? How's
That's
that?
great. That's great. Thank you.
Okay.
Looks like the occupancy start date is pretty small, but that's just because it's a lot of words in there.
Yeah, and what I put on there at line 9, I'll read it to you. occupancy start date, and I typed in upon lease execution, immediately available. All right. So if you had a tenant in place, for instance, and you were taking this listing while a tenant was already in place and they're moving out at the end of the month, you might put September 1st in here for a start date, possibly occupancy date. But in this case, this property is vacant, so I'm just going to put upon lease execution. All right. So John Doe is the owner at line 3. The address is 123 Main Street, Sleepy Hollow, Illinois, in Kane County. We're renting it unfurnished. It has an attached garage. The monthly rent is $4,200. We have a move-in deposit of $4,200. That's the security deposit. We're asking for a 1-year minimum lease. And the items to remain with the property are the refrigerator, stove, dishwasher, washer, dryer, 4 ceiling fans, garage door opener, lawnmower, shovel for snow removal. We're not giving them a plow. We're going to go down to pets. Pets permitted, 1 dog, maximum weight of 50 pounds, maximum number of pets, 1, pet deposit, $1,000. All right. Let me delve into emotional support animals at this point in time. If you're taking a listing, you need to make your landlord aware that they cannot discriminate against people with emotional support animals or therapy animals of any kind, whether it be, unfortunately, a dog, cat, lizard, turkey, I don't know. Even associations have to accommodate if it is a support animal or a therapy animal, okay? Does everybody understand? And you need to explain that to your landlords. If they say, if you have a landlord that says to you, I don't want people with children, walk away. If your landlord says, I will not allow any animals in my building, walk away, because you're the one that will be punished if you pursue that. If the landlord says, now here's a big one, I don't want any Section 8 tenants, walk away. Seriously. Let me talk to you about Section 8 tenants for a minute. One of the biggest cause of lawsuits currently in our area are people being sued because they did not handle the questions from a Section 8 voucher holder correctly. When someone calls you up and you have a rental listing and they say to you, and they all do, will you accept a voucher holder or a Section 8 tenant? Your answer should be absolutely, of course. What do you say next? You don't say anything else except please fill out an application. That's all. Don't ask any more questions. Don't ask them about their income or their ability to pay the utilities. Don't go anywhere else. Just say, please fill out an application. Landlord has credit standards that must be met, and we'll be happy to review your application as soon as we receive it. Does that make sense to you? Okay. I want you to be very careful, very careful. We've had a number of suits regarding this issue in the last 12 months, and they typically win. It doesn't even go before a court or a judge. It's done by a panel. All right. And these panel members are very, very mean. Okay. The term of the agreement goes from 8/22 of 25.
The house in front of Sandberg and Margaret, how many of them all of a sudden became runners? You know,
I can't hear you. I'm sorry.
some
Let me
runners.
see who's talking in the background, and I will mute them for you, Sandy.
Okay, I thought he was talking to me though.
No, he's got the TV on.
Oh, okay. Thank you. Okay. This particular listing agreement will go until February 21st of 26. I hope it is rented within the week, but you know, you never know. You insert your name at line 23 as the designated agent of this landlord, okay? And we have two different listing forms uploaded for you, one with my initials and signature on them, and the other one is without my initials and signature. The new agent office, people will be using the ones without my signature because they have a different managing broker, okay?
So Sandy, I had one question. I'm sorry to interrupt.
That's okay.
In regards to not asking them what they make per month income wise, or like if what their credit score is, and a lot of times we don't get to see what their credit score is unless an agent kind of discloses it because it goes to a separate link and all of that. You know, the application, I think on there it might say what your income is. I know a lot of landlords ask for 3 times the rent on the MLS, things like that. How do we know personally if they qualify before having them submit an application? Like,
Well, first of all, I think personally it's a mistake to put on the MLS that the landlord requires a certain income, because that is automatically considered discrimination against voucher holders.
got it.
So I would discourage a landlord from wanting to make that representation.
Okay.
I think it's okay for you to put on a MLS listing that the landlord is considering all applicants with a credit score of 720 or 7, whatever level that you decide is acceptable to you or the landlord. I think that's okay.
Okay.
And if they want to go ahead and proceed with the application, and at least you've told them, chances are we're not going to approve you with the credit score below that number. If it comes in lower, you just go, oh, well. And
Yeah.
you can see all the other issues when that report comes in. Okay.
Right. Because a lot of the renters, you know, they don't want to waste their time or their money to do these application fees.
Right.
Not going to qualify,
Right.
you know. So, you know, I mean, obviously we can't give them a guarantee that they're going to qualify
Right.
based upon what the landlord decides.
And truly, you might have 10 good applicants. You might have such good applicants, it's hard to decide which one. And somebody's going to be disappointed, unfortunately, even though they're qualified.
Right. And the
Okay.
emotional support dog, do they need to have paperwork to prove it's an emotional support dog or no?
Yes,
Okay.
but you know, I can get one in 5 minutes on the internet,
Yeah.
and it's signed by a doctor on the internet, so service animals, emotional support animals, this is rampant right now. I had a tenant about 2 years ago say to me, I've got all these little dogs and they're all certified. I go, what? Yeah, I got it done last night before I knew I was meeting with you today. So I got all my dogs certified as emotional support animals last night on the internet.
Hmm.
And you need to prepare your landlord that this is a distinct possibility.
Right.
All right.
So when you call to like kind of do the screening process with the renter, say it was like a lead that you just got from like Zillow or something, apartments.com, and they don't really give you any information on it, you can just ask them, you know, how many people will occupy the residence, like if are there any animals?
I don't think I'd do that on the phone.
No.
No.
Okay.
No, I think that could lead you down a path that somebody could say you're trying to discriminate. I don't
Gotcha.
think we should ask how many people. If the application comes in and you find out it's a 2-bedroom condo and they want to move 7 people in, you call the village. If everything else about the application is perfect, the credit is perfect, the income is perfect, the background check is perfect, and your landlord is like, all sorts of nervous because there are 8 people wanting to move into this 600 square foot condo, then you call the village or the city and say, do you have occupancy restrictions? Okay. You
Yeah.
should be the one making that decision.
And how do you know?
You call the building department.
No,
and
how
tell
do
them.
you know how many people are in if you do not ask them?
It's on the application how many people are going to be living there.
Okay.
Mm.
All right.
Just
I
take
don't.
your email address, or not address, phone number, and ask them if and don't ask about animals, don't ask about people. So just those 3 things.
Here's the thing, you can say the landlord does not want pets, Pets are not emotional support animals. Pets are not service animals. Okay? Landlord has the right to say no pets, but a
Mhm.
landlord cannot say no service animals.
Right.
Okay?
Okay.
And a landlord cannot say no children.
Right.
Okay?
Can the landlord say maximum three people?
No. Not unless it is a restriction from the village.
Mm,
Okay? So if the village says a one-bedroom apartment can only be occupied by a maximum of 3 people, then yes, you can. But you better have that documented, and you better have it from the building and zoning department from the city that you're leasing that property in. Okay?
hmm
I would also advise everyone here, before you take a rental listing, make sure that you know what the restrictions are in the locale that you're in. For instance, in Mount Prospect, you have to apply for the right to rent a property. And the owner of the property is actually supposed to, I think, take a course. It used to be that way 2, 3 years ago, prior to renting a property. In Hanover Park, the person who is going to be handling the rental, if it's the owner, they have to attend a 2-day course. If it is the agent, on behalf of the owner, the agent has to attend a 2-day course to get certified. Okay, so there are a lot of things you need to know prior to, you just don't go out and list a property without any knowledge, okay?
And one more last question. Is it fair enough to ask the client, if you've never met them before, don't know anything about them or anything like that, to fill out an application prior to showing them the place, just so to know that they're like serious about it and to know more about it without asking them about them?
Well, are you talking, are you
Like if you
talking?
get like a cold lead, like Zillow or anything like that. all
Yeah,
you do
well,
is go
if
from-
you might want, if you get a lead from Zillow and you're
Yeah.
just an agent, you're not the listing agent.
Right.
I think you have a lot more scrutiny if you're the listing agent, but if you're the tenant's agent, you can have a conversation with the tenant and say, do you know what your credit score is? Do you know what you can afford? Have you ever had your credit pulled before? Have them fill out the board application, but explain to them that many of the listings that they're going to encounter will have a link that they have to apply through an online link. Now, the recent changes in the law say that if the tenant has gone to, say, Remax last week and done their application, had their credit pull done, and they didn't get that unit, they can then take that, if it's a one of the major credit bureaus that did the pull on the credit, they can then use that credit again for your listing. And they can
Right.
submit it to you. And as long as it's less than 30 days old,
Right.
30 days
Okay.
or less, okay?
Yep. Thank you.
But it cannot be handed to you, say, because, for instance, if Remax pulled their credit 25 days ago and they got a copy of it, and then they want to just hand you a copy, that could have been altered. So it has to be sent directly from the credit reporting agency. All right?
Okay.
All right.
I
Cindy,
have a
couple
question.
questions.
I have a question regarding the income situation.
Yeah.
How the landlord can determine who can afford to pay the rent if he cannot ask for 3 times rent? 3 times rent. I mean income 3 times rent, for example.
Well, the landlord's going to see what their income is on the application.
And then he can say that your income is too low to afford this place.
Then he can make that decision as long as they're not a Section 8 tenant.
What about Section 8 tenant?
You are not allowed to discriminate because the government is paying their rent.
But often the government is paying just portion. They can qualify, for example, for certain amount,
Right.
and then they still have some kind of income. That's why I
Well,
thought we can ask for 3 times rent as long as we require this from every tenant.
well, you can't require 3 times rent from a Section 8 tenant. It's against the law.
So how the landlord can say no to them if the income is too low. If just the rent is covered, for example, if the voucher is enough to cover the rent, but it's not enough for living expenses, they still have to pay
Well,
utilities, food, like
I
other
have
expenses.
not had this happen, and actually, as long as they've got enough residual income, let's say they're getting Medicaid, or they're getting a lot of them have SSI income as well as voucher. As long as it's enough to cover the typical utilities, the landlord shouldn't care.
Okay.
Mm.
All
So
right.
to other tenants who won't have the vouchers, they still can be asked 3 times rent?
Well, I wouldn't put that on my listing.
I understand, but in the
Yeah.
conversation with them,
Yeah,
okay.
you can establish whatever criteria you want. I think 3 times the rent is a lot. But that's up to you and your landlord. I think you make the job harder on yourself than you need it to be.
Oh no,
Let
this is always coming from the landlord. I don't
I
think
know.
it's necessary, but I have landlords
Okay.
I work with who require
I
that.
know. I think what you guys need to understand also is that I don't know, Sonia, you probably know better than I, but the majority of the suits we've had in the last 2 years have been as a result of rentals.
Oh,
Um,
boy.
They
and
have.
this,
They
and
have.
this,
If I actually would give any advice, it would be don't take them. It sounds so
Wow.
traumatic, but truly to
I
make
know.
$1,600 but owe 20,000 is not worth it. And it is because of Section 8 and everyone is filing discrimination. If you say
Yeah.
no to a tenant, they run to their attorney and they hire an attorney and they claim discrimination. Discrimination against income, discrimination against race, discrimination against animals. That's why what Sandy is advising you is to say less, barely say anything. Just yes,
Exactly.
yes, yes to everything, and
Yes.
then let the documents do the talking. Because what you say is why all of these lawsuits are getting going into effect. And of course, the attorneys are living the dream. They're loving
Yeah.
it.
Yeah.
So we
They're the
need to stop
ones
that.
making all the money off of this.
My God.
Yes. Yes,
And
discrimination lawsuits are rampant and they're all due to rentals. I would advise my landlords, list it yourself. Go pay $30 and put it on Trulia. I'm
yeah,
sorry to say, but I really would, because it is not worth the $16,000 to $20,000 fines that we are getting for these lawsuits.
exactly. And keep in mind, guys, you're not making that much money on a rental. I
No.
mean, no, and you're paying, you're paying company dollars too. And it's a lot of work. You probably do as much work on a rental as you do on a sale. And so I would say do your best to avoid them. And I actually, with the person that called me this morning and said, we've decided we don't want to try and do this ourselves. I had asked them 3 months ago, please put it on Zillow yourself. And they didn't do it. So,
Thank
serious.
you.
All right, let's go on to the
Sandy,
rest.
I do have a couple questions. One is, I want to go back to the flood. Is that for all of Illinois or all of Cook County?
All of Illinois.
Illinois.
Okay, Illinois. The other question I was going to say about, I know Section 8, you can't discriminate against source of income. So is it safe to say, I mean, I don't take rentals, I decline them all the time, but credit report, like ultimately the landlord will review all applications. So just being safe to say landlord reviews all application, minimum credit score of whatever, and no pets. However, I want to ask about the pet thing again. If it's a support animal, you're not allowed to take a deposit, is that correct?
That is correct.
Okay,
That
so
is
no
correct.
deposits for support animal.
Right.
Okay, just making
All
sure.
right.
Sandy, I have a question. I'm sorry. So if the landlord decides to not take an application just to avoid like discrimination or whatever, the reason might be, are we supposed to provide the applicant like a denial letter or something, or just
Yes.
give them, like a
And
reason?
it should be written by the landlord, not by you.
Oh, okay. Okay. Yeah, because I usually like send them a text or I'll call them and I'll say, hey, I'm sorry they didn't accept because, whatever the reason was.
I don't think that's a good idea. I think it's a
Okay.
better idea to have your landlord write an email to you saying, with regard to Mrs. Jones' application for my rental I hereby decline this because after reviewing the application, I've decided her credit did not meet our standards.
Okay. Okay. Thank you.
Okay, let it come from the landlord, have it be signed by the landlord. That way you won't get blamed.
That
Okay.
was the perfect question, Carla. That was really the perfect question because
Yeah.
that's when yes, that was
So
good.
it sounds like the only out that is safe for a landlord, because I have investors, they buy rentals and then I list them for rent, okay? I don't go looking for, if someone calls me, I won't rent their thing. It's just this one person or two people. Anyhow, so they're only out legally and for protection and for ours is the credits, regardless of whatever's on that report, they can say the credit did not meet our standards, period. And that protects us. And
that protects us. Now,
Okay.
does everyone here understand, or are you aware of the fact that the background check in Cook County cannot be done until the credit has been approved?
Oh,
That's a big one. All right. So the company that we've got doing our credit and background checks will not move forward with the background check until you've said, oh, the credit's A-okay. Now, what if the background check shows that this person's got 85 convictions for methamphetamine?
Oh, well.
Okay. Yeah, that's and stuff like this happens, guys. That's what you're getting into with rentals. That's why they're so scary.
is there a place that we can go look to see which towns require the landlord or the agent to go to that course? I know Palatine does, but I don't know other than the ones you mentioned.
You actually have to call each and every village. That's the only way I know. Okay.
In Chicago, am I correct that you cannot do a background check?
I thought you could as long as the credit was already approved. I don't know that you can use it to discriminate, but I'd want to know who's moving in. I'd want to know if this person is on an ankle monitor. Another thing, you guys should avail how many of you are using Forewarn regularly?
I do.
Does everybody here know that you have Forewarn for free from the Board of Realtors? And whenever you get a call, I use it all the time when I get calls that I don't recognize on my phone.
Sandy, I was told with Forewarn when I first got it that beware, if you use it for one person, you have to use it for every single person. Like to look them up. You can't just go, gee, that one's kind of scary sounding. I'm looking that one up. No, if you start, you got to do every single person.
Well, if it's a number I don't know, if my mother's calling me, I don't run her through Forewarn.
Well, no, I don't mean your mother and friends and family, but I'm talking about in the business when someone.
Absolutely. Everybody gets run through Forewarn on my phone before I do business with them. Not only that, but it'll also show you if they are really who they say they are. If they call you up, for instance, and say, I want to list my lot, and a lot of this is going on lately. I have a lot in Geneva that I want to list with you. I'm the owner. My name is Sam Smith. I own the property. And then they want you to list their lot. This has happened to us a lot in the last couple of years where we've had agents taking vacant land listings and it turned out that they listed it for a fraudulent person. This has happened twice in the last 2 years to us. And the real owners came forward and said, whoa, why do you have my property listed? If they had used Forewarn, some of these people actually have phony driver's licenses with the name of the supposed owner that they've bought these fraudulent driver's licenses. So you need to be very, very cautious, especially this is going on a lot with vacant land.
Okay, so then someone calls, you don't answer it because you get inundated and you're like, I'll just see if they leave a message. And so then you're like, okay, I'm going to check this phone number. And now you don't return their calls. Well, the office has told me that you better call everybody back that, and don't ghost them, because then the office gets phone calls and
Right.
complaints. But if I
Right.
see something suspicious on Forewarn, I can't be like, hey, I looked you up on Forewarn, I'm not working with you, I don't trust you. I mean, you know what I mean? It's like we're
I think
screwed
you,
every which way here.
I think you talk to that person and say, according to my records, you are not who you say you are. And if that's the case and they're really not legit, they'll hang up on you as soon as you say that. Okay? And let's say, for instance, Forewarn isn't 100% either, guys. Because Forewarn sometimes has 6 people listed for that one phone number, and you don't know which of those 6 people. It could be somebody new that just got assigned that phone number last week, and Forewarn isn't up to date yet. Okay? So it's a tool. It's a tool, one of many we use. Okay? So I just want you to be careful. Let's go on to this listing agreement and get this done. The obligations of the brokerage firm and the broker are to gather and maintain relevant rental information, coordinate property showings, make diligent efforts to lease the property, advertise the property as needed, list the property on the MLS, and encourage other licensed agents to show the property. All right. If there is a municipal landlord tenant ordinance, it will be included with any lease. And a lot of entities like Mount Prospect, for instance, do have landlord tenant ordinances that they make you use. The owner's responsibilities: fully cooperate with the brokerage firm and refer all rental inquiries to them. Handle all lease negotiations through the brokerage firm. Permit the placement of for rent or for lease signs. Allow the use of a lockbox for showings. Provide reasonable access for viewings if the property is occupied. I would also add that I think it is a big mistake for you to continue to use combo lockboxes. They are not secure, and I think you're inviting trouble, especially if it's a very expensive property where something could go missing. Okay? I want to keep track of who is going into my listing. And if you have a combo box, there is no stopping an agent from giving that combination to her clients, and they can go back whenever they want to, especially if the property is vacant. All right? Let's go down to compensation. This is your commission. The owner agrees to pay the brokerage firm a commission of, and I've written in 50% of the first month's rent if the property is rented during the term of this agreement. This applies whether the lease is secured by the broker, the brokerage firm, the owner, or through any other source. Cooperating brokerage compensation. I think the easiest way to do a rental listing, quite honestly, is to put co-op compensation on this agreement. I think it's the cleanest way, and I'll explain why I feel that way. In a sale, for instance, we discourage you from offering co-op compensation on your lease, on your listing agreement, because of the fact that we feel the owner should decide when they see that offer how much they're going to pay. All right. And we have a title company that is going to divvy up the money at the closing, and they're going to take money from the seller if the seller agrees on the 8.0 contract to pay commission to the buyer's broker. They're going to take that from the seller at the closing, and then they're going to pay us what we owe. But there is no closing for a rental, okay? And so if we don't offer cooperating compensation to the other broker on our listing agreement, then we're going to have to divide that money up after the rental lease is signed. And ordinarily we collect 1 month's rent, all right, from the landlord, because and we have the tenant deposit that in our account, in our online account. But if we're only getting 50% of the first month's rent, that would either mean that our accounting department would have to send out a check to the other to the landlord for the other half a month's rent. I don't think they'd really like that. Or the landlord is going to have to pay us that 50% directly and then send the other 50% to the other broker. I think it's much easier for us to collect the full month and then to pay the other agent. Don't you agree, Sonia?
Yes, absolutely. I agree with you, Sandy. I know that it's a bit of a struggle. The landlord usually, yes, I'm just going to say yes and just stop at that.
I just think it's easier bookkeeping wise. But if you have a landlord that says, no, I'm not agreeing to any compensation, and we do have occasions, then you would put a 0 in here. Let's say this happens where the landlord doesn't want to pay the cooperating broker, and I'm going to take it out, and I'm going to put in a 0 here. And the landlord says, I'll decide later. And it comes time that we get an offer on the house, offer on the apartment, and landlord says, I'm still not paying. Okay, fine. Then he's going to send us either through our link, our 50%, and the other broker is maybe going to be paid by their tenant, or perhaps the landlord will change his mind at the time the lease comes in and agree to give them something. In that case, the landlord is going to have to pay them. All right. If you've got a 0 on our listing agreement for co-op compensation, we do not put them on our commission/compensation statement. Okay?
I have 2 questions if you don't mind.
Yeah.
So let's, in this world of this craziness with rentals, let's just say that the landlord's like, you know what, I'm just going to pay the person, the brokers that list it. Okay. All right. And we agree.
Mhm.
Because he says, you know, when I bought it, I had to pay my agent. Everything's changed now. Can we tell the tenants we don't work for free? In order to, for me to find you a rental, you're gonna have to pay me half a month's rent. Those that are like, can't and whatever, can't we, that's a way to eliminate people that wouldn't be able to afford it.
Yep.
And so we legally can say, look, if, you know, here's my fee to find you a rental. Otherwise they just leave. And do you see what I mean?
That's a retainer fee, and you're entitled to ask for a retainer fee.
Okay. Then the next question is, and this is something that's going on. So a tenant moved into a property and then decided, for whatever reason, she came up with ideas of why she didn't want to stay there. And she moved her stuff in and whatever. So now when this is what really gets confusing, and it's kind of frustrating, and I know maybe it's a legalese thing, but when there's first month's rent and a security deposit involved, I'm using the words just to use the words to separate, okay? They Zoom, or they give their Zelle or whatever it's called, the money to the landlord, and that's half month's rent, and then they do a wire or something to our office, and that's called, no. Ours is called first month's rent, which they're sending to the landlord is called security deposit.
Correct.
But now the problem lies with, that's not really how it is. That's really a lie. It's word salad, because really the landlord's really getting the first month's rent and we're getting the security deposit, because that's what they pay it out as. So now she wants her money back. The attorneys are involved. One attorney says no, and they're coming to an agreement. The other one is like, yes. So then where do we delineate so the agents who done their jobs get paid? Because now it's like, well, if it's called first month's rent and it goes to our office, and the attorneys are like, well, okay, we'll give her the security deposit back. We're going to keep the first month's rent. Do you see what I'm saying? It's like,
first of all, your error comes in. We do not accept security deposit.
Okay, I know that. I know. I'm sorry. Our office, we call it first month's rent that we collect.
That is correct.
And then the landlord calls, he's collecting security deposit.
Correct.
Okay.
Right.
But when the attorneys are now dealing with this stuff, the landlord wants to keep his first month's rent, which went to our office, and our payment went to him. But you guys pay us through the money that comes to the office, which is called first month's rent. Do you see what I'm trying to say? So now the attorneys are trying to delineate. So they're saying, well, you know, in the form she sent to the HomeSmart office, it says it's first month's rent. Okay, so now but then the landlord is like, whoa, I'm not giving her the money she's out to me.
And
You see what I'm saying? It kind of convolutes
That
the whole
is-
process.
well, in many cases, when this happens, they're gonna ask the realtors for the money back. Okay,
Well-
I've seen that happen numerous times. But if the tenant moved into the property legally, even if you only even if you only live there for one day,
Mm-hmm.
you are obligated to pay the full month's rent.
Right.
So why should you get the money back?
I agree, but that's the whole fight right now. But the
Well-
attorneys who frankly don't even want to do this because it's a pain in their butts. They don't
I
make
know.
anything.
But
And
between the
so-
attorneys and the landlord, and they can negotiate with the realtors for the money back if the tenant is a bad tenant, but it's entirely up to the attorneys,
Yeah.
all right?
All right. Do you see what I mean though? Because then what happens is then the tenants get very confused about what they've given and what they're getting back even in a year.
Well,
But you can also
security
say
deposit cannot
non-refundable.
be- Security deposit cannot be used for anything other than to guarantee that the property is returned in the condition that it was delivered to the tenant in the
So
first.
then let's just say that the landlord says, send me the first month's rent and the security deposit, do it through Zelle on 2 payments.
Yeah,
And then, okay, but he's paying 1 month's rent to the agents on both sides, 1 and 1. Now he's gonna use his security deposit to send to us. It just
Well-
to me, it's like, is this just like shell game? You know what I mean?
no, you're misunderstanding these terms. The landlord
No.
by law has to put that security deposit into an account. He cannot be using that money. So if the landlord wants to pay us, the landlord is entitled to do that. We do not have to collect first month's rent. The landlord can pay us through our link as well. But the landlord by law cannot use that security deposit to pay any.
Well, I know, but when you have, let's just say it's 1,000 and 1,000, and then the landlord sends us 1,000, I mean, the dollars don't say this is this on it, and this, you see what I'm saying? It's just like, it's words, I think is what it is, of how
Well,
how the words are.
When the tenant issues money to the landlord, 1 month's rent is labeled 1 month's rent, and the security deposit is labeled as such.
I know that, I understand that. But when he sends it, he's gonna send it, he's not gonna oh, where's my envelope with that in it when they're the same? Do you see what I mean?
He would have deposited the security deposit, hopefully in an interest-bearing account.
Wait, I thought they didn't have to do interest-bearing accounts.
Yeah.
That's new to me.
As far
That's
as
why
I
so
know.
many of the landlords are moving to what
Yeah.
they're calling move-in fees instead of security.
Right, and that's what we've been doing, is moving
No,
fees and non-refundable security deposits.
Well, they are supposed to be in interest-bearing account.
That's correct.
All right, yeah, I know that was that way, and I know it switched, and I don't know. Okay, well, thank you for answering my questions.
You're
Oh,
welcome.
so sorry, Sandy. Sorry to.
Oh, no, it's okay.
But in respect to that, so he got his first month's rent, and then that's what the agents supposedly get, where they get their half a month's rent from. Then wouldn't he still have to pay the agents if she's paid him his first month's rent and he gets to keep it if the attorneys decide upon that?
She paid it to the office, not to him.
Right. So wouldn't the office be able to pay out the agents and say,
Yes.
well,
Yes.
this is their compensation, you agreed upon it if they found a
Yes.
renter?
Yes, unless the agents agree, and sometimes the agents, to make everybody happy, agree to give back either all or a portion of the money they've been paid. And I've seen that happen on occasion when a tenant defaults. All right,
Mhm.
but it's a negotiation. All right, let's move on. Otherwise, we're going to be here all day.
Yeah.
Additional compensation. This is your listing, okay? And let's say you get an unrepresented tenant and you give them a notice of no agency. You ask them, are you represented by a licensed real estate professional? And they say no, and they want to move forward and rent this property. I've inserted here that the landlord is going to give me $1,000. I'm not asking for a half a month's rent, okay? Sonia, I wanted to point out to you, line 65 on this form is not fillable.
Okay, thank you.
All right.
Noted. You got it.
Additionally, if the property is leased to a tenant who is introduced or shown the property during the term of this agreement and the lease is signed, normally I put in here within 60 days after the agreement ends, the commission shall still be due. Okay, this is your protection period. Let's go down.
Sandy, can I just interrupt real quick with one question?
Uh-huh.
On the previous page. So this is a new rental agreement as of the 18th of August. And I currently have a rental agreement with a landlord who's going to activate today, in fact. We signed it in July on a previous version where there was no provision for offering the co-op compensation to the tenant's agent.
Do you have a copy of that with you right now?
Yeah.
Okay, I think what you're missing here is under payment of marketing fees, line 84 on mine, but it is on yours on the older version as well. That's the co-op compensation. Take a look at line 83. A cooperating broker will receive a minimum of, I've reiterated it here, and it is on the older version as well.
So mine is dated 7/15/25.
Look for a paragraph that says payment of marketing fees.
Huh.
Do you see it?
Nope. Oh, right, there it is. Right. Okay, so we need to modify that then so that, because at the time we were doing this.
You didn't notice it, right?
No, I did notice it. We have 0 in there.
Okay, that should be your co-op compensation.
Okay.
A cooperating broker will receive a minimum of, and even though I had it on the previous page, I put it in here too. We could probably get rid of this line on this particular lease listing agreement right now, because we've got it on the previous page. But I put it in here to alert you all that the previous versions of this is where the co-op compensation is.
Okay, because that was my concern, was how that co-op broker was going to get paid out with the collection of the first month's rent.
Okay,
Thank you.
does that help you now?
Yes, I'm going to have that modified so that
Okay.
it's very straightforward.
All right, should the tenant and owner agree to extend the lease beyond the original term, I'm going to ask for an additional 1 month rent. If the tenant ultimately purchases the property during the terms of the lease or any extension, I'm going to ask for 5% of the purchase price at line 75. Paragraph 10, the owner acknowledges that prospective tenants may choose to be represented by their own real estate agent who may not be affiliated with the owner's designated broker. Easy. Payment of marketing fees. We already discussed that. Let's go down. Property management disclaimer. This paragraph basically tells the landlord, we don't manage your property for you. We're only here to get your house rented and find you a good tenant and to show the property to prospective tenants. Okay? And my dog walker just arrived, so you're going to hear some barking. I'm sorry. Modifications of this listing agreement must always be in writing. When I present this document to a prospective landlord, I make them read the fair housing paragraph. It is essential that your landlord understand they cannot discriminate against any of the categories that are stated in this paragraph. None. Okay? Illinois law. All right. Illinois is stricter than a lot of other states. I must have owner's initials on this paragraph. If they refuse to initial here, walk away. Do not take the listing. Okay. The owner affirms that they have full legal authority to enter into this agreement. We cannot accept a listing from somebody who is related to the owner, who does not have written power of attorney, all right? So make sure you get that. If somebody says to you, I got a call last week from someone who said, I want this taken out of the private network and put on the standard network within the hour. He was a brother-in-law of the seller. I said, I'm sorry, sir, you're not party to this listing agreement. I cannot talk to you. Okay? So do not take direction from anyone but a principal. All right? Owner's disclosures. The owner is solely responsible for providing accurate information about the property's condition. The brokerage firm and broker are not required to verify these details. All right? Indemnification for property-related issues. The owner agrees to indemnify and hold harmless the brokerage firm, its affiliated brokers, agents, employees, successors, assigns from all claims liabilities. All right. The next paragraph tells your landlord that you may represent other clients, that you don't work just for them. Most people understand this, but you'd be surprised. Some people think they're the only one in town and that you're going to work only with them for the next 6 months. Dual agency disclosure and consent. This is up to you. I will reiterate that I normally refuse dual agency. You put your name on line 132. All right. I make my both sellers and landlords read this entire section. And then if they want me to do dual agency, they would initial here. When I take this listing, I cross it out and say refused. All right. It's up to you. Now I have a new listing I took about a month ago, and they're not ready to put it on the market yet, but they wanted to do the paperwork. And when this paragraph came to be read, I said to them, okay, I understand you don't want me to be a dual agent. How do you feel about me when an unrepresented buyer contacts me and wants to see your house? Will you allow me to show it to an unrepresented buyer with no agency? And this particular seller said, I used to be a real estate agent. I don't want you doing that. I think you should just refer those people out to other agents. I do not want you bringing a buyer through my house because I feel that's a conflict. And, you know, you need to have that conversation. There are people that feel that way. Okay. Any questions? This document represents the full and final agreement between the parties. Read this over. If you've got any questions, feel free to ask. Everybody signs the back page. All right. Should always have all owners sign. Okay. Any questions?
So
Yes.
sorry. So say that they wanted, they allowed you to bring that unrepresented buyer in, and then they want to make an offer. Now that is dual agency.
No,
No?
not if you've done, no. There's a difference between no agency and dual agency. If that unrepresented buyer comes and your seller does not want you to do dual agency, but they will allow you to show an unrepresented buyer that house, you give, before that buyer enters the house, you give them a notice of no agency.
Mm-hmm.
When they come in and they say, oh, you know, I really like this, I want to rent this property. Fine. You can perform the tasks under no agency. You do not have to be a dual agent.
Oh, yeah, I get what you mean. It's for rental. That's right. We're not, I
Well,
was talking
for
about
a sale, same thing for a sale. You do
Oh.
not have to become a dual agent. If your
You don't give them
landlord,
any advice, basically. That's what it
What?
means, no agency.
no agency means you can give them comps if they ask you for comps.
Uh-huh.
If they ask you how to bid, you cannot advise them.
Okay, gotcha.
All right?
Yep.
All right. So let me show you this other form that I was talking to Sonia and you about earlier. And I better make this a lot bigger.
I have a quick question.
Yeah.
If you, our MLS, everything goes on to the Zillow rentals also. When I do a rental, I get many people coming through inquiring about the property, the rental without an agent. But I do correspond with them. So what am I doing? Am I a no agency, or my landlord said, tell them, get the applications, send them to me. Am I doing the listing side, or am I trying to do both sides and not realizing it?
Well, if it's your listing, you make a decision with the landlord when you take that listing, first of all, whether you're going to do dual agency or not. And second of all, whether he's going to allow you to represent an unrepresented buyer with no agency. You have to have that conversation with him. If he says, yes, you can bring somebody in with no agency, then you can show the property, you can write up the lease, but you cannot advise the tenant
So
under no agency.
So when I write up the lease for these for tenants that come through Zillow that are not represented, it's a standard lease. The landlord states what they want. But I'm not getting any compensation for that part.
Well, Barbara, what did you put on your listing agreement? Did you put
as a listing agent, I get 1 month's rent as a listing agent.
Oh, well, then that's different. But our listing agreement also has a line that says how much you will earn if you show the property to an unrepresented tenant that pursues that property and ends up leasing it.
But I'm already getting 100%.
Well, that's up to you then. If you want to do it for nothing on both sides, that's fine.
So, if I had a 1 month's rent, because things are more complicated this last year, and the landlord, now the grass cutters are coming. The landlord wants to pay, doesn't want to pay a second commission. When I went to put it in the RSA, they charged me $55 for putting the tenant's name in, even though I didn't make any commission.
They didn't charge you for putting a tenant's name in. What?
Oh, so when I went to the RSA and I put in the that it was rented,
Yeah.
I put that I represented the landlord, and it was 1 month's rent that I was getting paid. And then they asked me for the tenant's information, and I gave the tenant's information, and there was no monies being put to another broker.
Then
But they
that is
charged me.
something that you need to discuss with the accounting department. Sonia, do you have any suggestions there?
Yes, I've spoken with Bill about this. So apparently it is whenever we are doing a notice of no agency or a dual agency, either one, you are going to be billed that $55 fee. And the reason behind it is because you are actually at higher odds of being sued than someone who has an agent on the other side. So our errors and omissions insurance person advised us that that is the deal. It's a bigger risk for HomeSmart Connect. And so that is why we charge that risk reduction fee of $55 for both sides. So if you are going to represent both sides, you get charged $55.
It was really $110 for writing, for passing the paperwork back and forth between the landlord and the tenant.
If you don't want to pay that, Barbara, and you're not earning any extra money for it, why not refer that person out to another agent in the office?
Because the landlord wasn't paying anything to a broker.
Well, then.
Okay.
But she's not even representing them, she said. So where's the liability? They signed no agency.
We get sued for no agency as well as dual agency.
So either way, we're getting billed $55.
Yes. Okay. All right. Does everyone see the Chicago Association of Realtors landlord payment of tenant brokerage compensation agreement? This is what you would use if you've got a tenant for another, like a Coldwell Banker agent's listing, and they tell you that the landlord is going to pay you, Coldwell Banker is not paying you. This is what you would submit with your lease to make sure that the landlord is going to pay you. All right? The landlord signs the bottom as well as the tenant. And basically it says here, you put the tenant's name, the landlord's name, the address of the property, and the name of your brokerage, because you represent the tenant, and you're gonna fill out paragraph 4, how much that you're gonna earn for representing the tenant, okay? And this is something, at least something you've got if we need to go and pursue that landlord for payment later. Okay, this is a contract between the landlord and the tenant stating that the landlord agrees to pay you. All right? Because we have been told that there are a number of companies out there that have decided we're not gonna any longer be involved in this. We're gonna have the landlord pay you directly. All right? Now, Sonia, is there any possibility I could turn this back over to you, and could you upload that new commission statement?
Yes,
Possible.
yes. Here, give me a minute and we'll get that done in the background.
All right.
Is there, if anyone wants to ask a question while I'm pulling it up, you're welcome to.
Question, like the Chicago thing you just sent about sending it to the landlord for payment. So I'm confused. If we put on our listing, say it's a rental,
Yeah,
that we're gonna offer a co-op commission,
yes.
and then somebody comes with one of those, shouldn't we just put negotiable on there?
Not
Rather
if,
than the
if you
percentage?
have a co-op on your listing agreement,
Mhm.
no, then it's not negotiable. If you put negotiable, then you're gonna be using this form. That means you are not stating what your commission is.
No, what I'm saying is I'm confused. If you're listing the rental, right?
Yes,
And then somebody comes with that car thing with their tenant, and then
yeah.
it's a different commission, or how does that play out?
If we're paying the co-op commission,
Yeah,
they do not use this form.
but
They
how do
come
they
to
know?
us
And
with a broker-to-broker compensation statement.
okay, so how do we communicate that? Because we can't put that anywhere.
How do you communicate?
Well, like with
When they
the,
call you and they say, I have a tenant that wants to rent your apartment or your house that you have listed, are you paying commission? You say, my landlord has agreed to pay 50% of 1 month's rent, or my landlord is not willing to pay. And so if you say, we are paying what half of a month's rent to a co-op broker, then tell them to submit the broker-to-broker compensation agreement that is between us and the other broker. That's between HomeSmart Connect and whatever company the tenant's landlord is with. Okay? If we are not paying any co-op compensation, then they use this form between the landlord and the tenant.
gotcha, thank you.
Okay.
Can I ask about the broker to brokerage compensation form?
Sure.
What if, for example, I had the situation that I sent it to them for asking for signed, and they're just quiet and not answering me, nothing. What else? What can I do?
There's not much you can do except call the managing broker of that office and complain.
Mm-hmm. Okay. Thank
Okay.
you.
And sometimes they're stalling you because they don't want to cooperate. They're sending you a message essentially. Okay.
No. They send the money. They send the check.
Oh,
They just
oh. Well,
don't want to do
if we've
anything
already
else.
got the money, then I'm not so worried. I'm more worried about what happens when you do all the work and we don't get paid. And I'm trying to
Okay.
make sure that you get paid beforehand. If they've already given us the
Mm-mm.
money, then it's less important, okay?
Okay. Thank you.
Sonia, can everyone see the rental compensation agreement?
Yes, can everyone see this?
Yes.
Okay,
Perfect. All right.
basically, this is your commission statement for a rental. Once you've done a rental, you're gonna upload this so that Doc Review knows who's paying how much to whom. Okay, so you fill out the top paragraph, the landlord's name, the tenant's name, the cooperating brokerage if it's applicable, and your name as designated agent on line 8. Then we go down to subject property, you put in the address. Now, here's where it gets interesting. You either are going to use one of these 3 check boxes. Either at line 16, the owner landlord agrees to compensate Home Smart Connect and its designated agent as follows: either a percent of the total annual rent, like 50%, that was on my listing agreement, or a flat fee. Sometimes we get people who would prefer a flat fee, that's fine. And then going down further, in the event that HomeSmart Connect represents the landlord owner, HomeSmart agrees to pay the cooperating broker, you would insert at line 20 how much we're going to pay the cooperating broker, okay? So 50% there too, probably. All right. Or let's say you have a situation where your tenant says to you, find me a rental. I don't care if anybody else is going to pay your commission. I'm going to pay you a commission. I want to get into a house this week. I will give you money. Then you would check line 21. Tenant agrees to compensate the HomeSmart Connect and its designated agent as follows. Okay, whatever that is. All right. Then there's a third situation. Co-op broker agrees to compensate. This is not our listing. This is somebody else's listing. And co-op banker agrees to compensate the HomeSmart Connect and its designated agent as follows. Okay. So you use line 16, owner landlord agrees if it's our listing. Line 21, if you're representing a tenant and they're going to pay you your commission, tenant agrees. Or if it's somebody else's listing, line 24, co-op brokerage agrees. Okay. And then you fill out all the other information here. All right, the owner, the tenant, co-op brokerage information. Any questions?
Do we really mean 50% of the total annual rent? I mean, that sounds like half of.
Oh, it shouldn't be. It should be 50% of the first month's rent. Yeah, let's change that.
Yeah, that's throughout all 3 paragraphs.
Okay, I didn't
Yeah,
even
we'll
read
fix
that.
that. First month's
it's a
rent.
great compensation.
Yeah, that would be very healthy. Now, if we were commercial agents, all of us, they
Yes,
get a
that would
lot
be the
more money
case.
sometimes, okay?
Sandy, did you want to share? We did have signatures originally on here, and so if that becomes a question, Sandy, do you want to share why we removed the signatures?
You know, I just think it's going to be problematic, especially you're going to get this form completed after after you found a tenant, all right? And it may be difficult to collect signatures. If you guys think it would be not a problem to get signatures, that's fine. But this is basically for direction for doc reviews so that they know where this money is being distributed. I don't think it's ever going to guarantee anything. I don't know whether it would hold up in court, even if we had signatures on it. It's an attempt, but this is basically, and I had a discussion last week with someone because there are occasions when people get stiffed on rentals. And in the past, you know, it's been known that it costs you money to go out to arbitration with another company. And the typical cost is anywhere from $350 to $500 to go to arbitration. Maybe the rental commission is only $400. A lot of agents are just going to blow it off and say, I give up. You know, and I've talked to people, I think it's very unfair that on a rental you have to put up so much money to go to arbitration.
Can I just a real quick going back question? When you get a call, you list a rental and you get inundated, depending on the area, with a lot of people. And so, and you answer the phone and then they want to see 123 Main Street that you just listed.
Yeah.
Can I tell them I don't do dual representation? You have to find yourself an agent in order to see it.
You can do that if you've got written permission from your landlord to say that.
Okay, cool.
All right. And like I do on this new listing I took where he said to me, absolutely, I do not want you showing my house. And we put that on the listing agreement.
Okay, thank you.
All right.
I have
Just
a
wanna make
question,
sure I don't say
Sandra.
anything wrong, you know? Okay, bye.
I have
Go
a
ahead.
question, Sandra. I use my own for commercial commissions. I use my own like for years now. Kind of like what I do between brokers. Once we agree upon a price, either is purchase or lease. Is that okay to keep using that?
That's not a decision that I can make. Sonia, you have a comment?
My comment would be that I would love to see it. First of all, because it sounds like it might be a really wonderful form. But secondly, that we are trying to keep things cohesive in an attempt to streamline the process for our compliance department. The more different forms that we have, the harder it is for them to do their job. So I would love to see it before I answer that question. And as you'll see, like on that form we just shared, where where I'm going to be revising the rent portion of it, we try to put all three things into one. You know, who's paying it? Owner, tenant, co-op. We're trying to actually even condense the forms even
So
more.
that is between broker and broker, has nothing to do with a landlord. It's like very specific and very to the point. I would rather myself use whatever I use so far, not the company, because I feel more comfortable myself.
We have a broker to broker form, or broker agrees to pay the brokerage, and that would be something that I could share with you, and you could see if that is something that you believe is going to be enough coverage. But I would love to see your form. Let's just start there and let me see it, and we'll go over that together.
Sure, but as I said, I feel much more comfortable to use mine.
All right. Any other questions? I think we've run long, guys.
Can we get a copy of those forms that were filled out that you showed us as an example?
I
Yeah,
don't know whether you want them filled out because, but I can
Just
give
for
you
to look back, like as a sample.
a
Yeah.
sample would be nice, yes.
Yeah. All right.
I have one question about total application fee. I know it's going back to the beginning, but I missed about 15 minutes of this. Where do we find the total fee for the people to apply for, to rent, like credit check and background check? Can you clarify that?
That's listing to leasing, correct, Sonia?
Yes.
And
Yes, that's listing to leasing,
I
exactly.
believe it's, what is it, $75 per person?
That is correct. That's what it doesn't, it charges the applicant, the $75.
And
And there's a real easy way to do it. When you are in your listing in the MLS, excuse me, for that rental, excuse me, hold on a second. When you're in there, if you go under the additional documentation or additional information tab in your MLS listing, usually that would be where you would write a contract for an offer. Here it has apply now. And that apply now tab is where you can click that open. You can copy the URL and put it in the broker remarks of your listing, which I highly recommend you do. Or you can also use that, if you scroll down to the bottom, to email someone to invite them to apply. So there's an option there, as well as on the agent dashboard. If you go on the listing to leasing app, it shows all the addresses where we have rentals for lease, and you can send that to your clients as well to apply.
Is it a good idea to put in it $75 to apply on your MLS listing, the actual
Sure.
listing? Okay.
I mean, I don't think that they will flag that.
Okay, good.
And
sorry. Do we have to, we don't have to use that a listing to lease, correct?
No, you don't have to use it. Absolutely
Okay.
not. It's
Yeah.
just a great tool that we have for you if you would like to.
Too expensive. For most tenants that I've worked with, I thought it was very expensive per person.
Does it do a background check at the same time, or is that something special?
It is delayed, if I'm not mistaken.
Right.
You are correct. They follow the guidelines that they have to make sure that the credit is good first before they do the background check.
What if they already have like the credit check that you were talking about, where they give it to us from the credit bureau, and then they don't have to pay for that portion of getting their credit run?
Right.
Well, is there like a spot to put that in, like already provided agent credit report, just want to do background?
I don't believe there is.
I
No.
don't, from what I
No.
was told, that we can't piecemeal it. Is that correct, Sonia?
That is spot on. Yeah, it's all or nothing.
Yeah, you would probably have to use a different company for a background check if they come to you with just a credit report.
Oh, geez.
Okay.
Mm.
Yeah, it's a little bit more complicated.
What are the other companies?
Oh, there's a million of them.
Or-
All right. I think that's about it, unless there's anything else.
Thank
I
you.
just, it's $75 per applicant over age 18, correct?
Yes.
Okay.
Wasn't there a Smart Move one or something we used to do? Or no?
There is a company called My Smart Move, I believe.
It's
Okay, and they do credit and background?
Yep.
We used to use
I will
renters.
say that I saw a comment Bill had said on Facebook that he wants everybody to use listing to leasing, but I don't
Yeah.
know. Sonia may know more about that than
Does
I
the
do.
office get a cut from leasing to listing? Because I tried using it and not one person wanted to. They all said, forget it, it's too expensive.
Wow.
And so I wondered if that's a reason why it's more, because the office gets something from it.
I don't know the answer to that question.
Does
I
the
just know that
office,
when
is
we
it a
spoke with
realtor in the
listing,
office that started this lease to listing?
we
What?
have an agent with our company that works for listing to leasing. So we are trying to support one of our agents as well.
Okay,
So,
I just wondered.
but with that, we have looked into it, and they all are raising their prices, just like everything else in the world, right? All of these credit application companies are raising their prices. So I think as you start doing your research and looking into other companies, you're going to see we're not far off.
Okay.
I add that on my smart move, unfortunately in Illinois, once you send a link to the tenant, it won't let you unless you pay prepay, because apparently the laws in Illinois changed that tenant cannot be charged for their credit reports. That's only through my smart move.
Oh, that's right. The agent has to prepay for it in order to send a link, right? That's
Wow.
what.
Really?
Correct. So my smart move will not allow you or let you send the link to the tenant
Wow.
unless the agent prepays.
I don't think I'd like that.
I really don't like that. I was representing a tenant on a rental listing, and it was from the other HomeSmart from Naperville, the listing
Okay.
agent. And she said, well, the way I do it, I'll send the link, I'll pay, and then I'll ask him to reimburse me. I'm
Wow.
like, I'm not doing that.
Well, I wouldn't want to do that either.
They did change that when those laws were happening, but then I learned that that is not the case in Illinois anymore because it got shot down, but they haven't changed it back.
Okay. Well, we'll just work with what we got, guys. All right.
I have to add that listing to leasing actually worked very well for me. It is $69, but it worked very well, and the reports last for 60 days. And to me, I really loved it.
Well, that's good to hear. Good
Yes,
to hear.
thank you. We actually have been getting a lot of the agents who are using it are giving us raving reviews. So that
Excellent.
is something to keep in mind as well. Yes.
All
And
right.
maybe that $75 will really weed out the people that are interested and truly interested
Yeah,
in applying versus the ones who
exactly.
aren't. So,
Exactly. I
yes.
agree.
I
All
agree
right.
too.
All right,
Thank
guys.
you. Thank you
Have
all
a
for your
wonderful
time.
weekend, okay?
Quick question,
Thank you so
Sandy,
much,
before we
Sandy.
go.
Yeah.
So I have a landlord, and he specifically asked that I have to put in the MLS that he wants 3 times the rent, and you were saying earlier that that's not allowed anymore.
Well, you can do it, but you are a Section 8 or a voucher holder could construe that as discriminating against them.
Can I put 3 times the rent, Section 8 welcome?
Well, that I no, because then you're telling them that you're requiring income from them, and we've been sued for that before.
Okay.
So I would say that the landlord has income. Let the landlord scrutinize the applicants, and he can decide if they don't have enough income once he sees their application.
Okay.
All right. And all you have to do is explain to the landlord what the problem is with asking for a certain amount of income.
Mhm.
And you know, you might get away with it, but I'd hate for you to be the one that gets caught up in that, where they say, oh, you discriminated against so and so. All right.
Okay.
All right. Let's
Hi.
see.
Will this section be recorded and then I can see it?
Yes.
I don't know.
Yes.
Okay,
Okay.
thank you.
All right, guys. Have a wonderful weekend.
Thank you, you too.
All right, guys, have a
Take
good
care.
one.
Bye-bye.
Bye, everyone. Thank you so much, Sandy.
Thank you. Bye.